Good morning, everyone. For years, advocates from both within and outside the Commonwealth of Pennsylvania have urged lawmakers to review the Pennsylvania system of incarceration. Eventually, sometime around 2011, 2012, revisionary pundits effectuated a philosophical shift in how we viewed the state system of corrections. Two distinct departments within our system, probation and parole and the Department of Corrections, were merged through memorandums of understanding under the leadership of one secretary. Now, some would argue, maybe quite persuasively, that it was less of a merger and more that the Department of Probation and Parole absorbed the Department of Corrections. But this unification was presented to the legislature as a means of eliminating redundancy, streamlining the parole and probation system, reducing prison populations, and most importantly, saving millions of dollars. This new model quickly resulted in decreasing prison populations, and one can only hope a savings to the Pennsylvania taxpayer. However, as a result, to rush the release of prisoners and save money, we have adopted a mechanical model of parole evaluations. And these evaluations do not distinguish between the violent offender, the sex offender, and everyone else. If we are grading our system on the consistency of our methodology, then we're doing a fantastic job. However, the process is never more important than the outcome. Clearly, we have had far too many horrific outcomes. We've had 6 murders committed by 5 parolees within a 2-month period of time. Now, I've been practicing criminal law for almost 20 years. I was a prosecutor and defense attorney with the United States Navy. I was a defense attorney in Pennsylvania and Ohio, and I am now the district attorney in Lawrence County. And my opinions are not rooted in academia, but rather have been developed through the trials of experience. And the belief that a murderer, a pedophile, and a drug addict can all be rehabilitated in the same way is not only naive, but it's also irresponsible. I understand that no system is perfect, and I know that there are a lot of smart people working very hard in addressing the shortcomings of our parole system. I have read the recent Senate bills 500, 501, 502, 14, all being offered up as justice reinvestment initiatives. These have all been supported by the governor. None of these bills, however, distinguish or even address the differences between violent offenders and other prisoners. None of them address how an inmate should be treated for parole purposes when they commit additional crimes or infractions while incarcerated. They are funding bills, substance treatment programming bills, crime victim communication improvement bills. They address how a convict is to be treated after release, not what should we be considering prior to an inmate's release. I've also read the internal review report ordered by Secretary Wetzel. The report reads as a justification of present practices, a defense of the rationale for paroling these 5 murderers, and offers up a few collateral recommendations for improvement. The problem with this report is that the evaluation of the DOC and the parole board has been ordered by the DOC and the parole board. And then it was conducted by the DOC and the parole board. They are investigating themselves, which everyone knows can never be effectively done. There was an argument put forward in Secretary Wetzel's report that the internal review was analogous to the reviews that are conducted by the NTSB after a plane crash. Well, the problem with that analogy is the NTSB does not own or operate the planes that crash. They are an independent federal organization that evaluates the practices of private airlines. They are not evaluating themselves. And you know there's a problem when one half of the organization, the Department of Corrections, their own personnel are requesting an outside independent evaluation of the organization that they are a member of. Now please, I don't want you to misunderstand me. I do not know Secretary Wetzel, and I know there are a lot of good men and women working very hard on the parole board and through the Department of Corrections. But we need to be honest, and we need to accept the fact that the families of murdered loved ones deserve to have answers, not excuses. We cannot change what has already occurred, but we have an obligation and a responsibility to make sure that this never happens again. There needs to be an independent evaluation of the Parole and Pardon Board and the Department of Corrections from top to bottom. And if it's all as they say it is, then they should never fear outside eyes. There was an article written by Katie Meyer from WHYY on July 31st, 2019, entitled, PA Corrections Secretary Cautions Against Knee-Jerk Reaction after parolee murders. Now, in that article, Secretary Wetzel is quoted as saying he would be happy to provide records to anyone interested in conducting an internal, independent interview. I can't speak to the facts and circumstances of the parolees in the other cases, but I can with regard to the Burley case. And I would take him up on that offer. The Office of the District Attorney has already requested the records. I have sent subpoenas to the Department of Corrections and to the Pardon and Parole Board. Now, I cannot release the contents of that information because it is part of our case. But since he is willing to offer up that information to the general public and to the media, I would request the transfer reports between prisons, the misconduct reports, the psychological reports, the intake reports, the classification or confinement status of inmates prior to their release, and finally, how was the vote made and what were the materials provided to each parole board member prior to their vote to release a convicted murderer. Maybe after what you see in those documents, we can take the steps to balance our desire, the desire of the present administration, to treat all inmates the same and ascend to the understanding that violent offenders do not even remotely resemble nonviolent offenders, and as such should be treated differently. I know that you are all aware of the facts detailed in the criminal complaint filed against Mr. Keith Burley, and I trust that you understand I'm very limited in my ability to discuss the facts and circumstances of that case while it is pending litigation. I can tell you that the charges filed against him, including the killing of little Marky Mason, were bound over on August 29th of 2019 to the Court of Common Pleas. And on September 2nd, 2019, I filed a notice of aggravating circumstances indicating the Commonwealth's desire to seek the death penalty in this case. The next step will be arraignment, and then we will move the case on to trial. Ladies and gentlemen, when this tragedy first occurred, the very first phone call that I received that was not a police officer was from State Representative Aaron Bernstein. He expressed remorse for the family and concern for all the men and women that are involved in the investigation of this case and simply asked, what can I do to help? I told him a little bit about my frustrations with the parole board that I've encountered over the years that I've been in office as it relates to violent offenders, and he told me, let me see what I can do. And now, ladies and gentlemen, here he is, advocating for the people in his district and the people in the Commonwealth of Pennsylvania. I want to take this opportunity to thank Representative Bernstein for his many past efforts on behalf of law enforcement, on behalf of my fellow district attorneys, and most importantly, on behalf of the victims in this senseless tragedy. So without further ado, Representative Bernstein.
Thank you so much, District Attorney Josh Lamacusa, for inviting me to be part of this press conference here at the Lawrence County Center. District Attorney Lamacusa has been instrumental in helping to develop this legislation. And not only is he an exceptional prosecutor for right here in Lawrence County, but his partnership in helping craft this proactive legislation will ensure that communities are safer by keeping violent criminals right where they should be, behind bars, across the entire Commonwealth of Pennsylvania. I also want to thank the family of Marky Mason, who provided insight into this legislation. Nothing can take away the pain of your loss, but I do hope that you find comfort in knowing that the legislation that we are announcing today can reduce the chances that violent criminals will be held accountable moving forward. Individuals who are incarcerated for violent offenses often reoffend while in prison, putting both correction officers and other rule-abiding inmates in danger. These incidents should serve as a red flag to our criminal justice system, but instead, we've seen numerous circumstances in which these inmates receive no additional penalty beyond their original sentence. These same criminals, as was the case with violent inmate Burley, are released at their minimum sentence of their original conviction. I have thoroughly reviewed the report of the PA Department of Corrections, and I believe that not only did their internal self-review lack depth and transparency, but the minor changes that they have recommended do not go far enough in ensuring that communities across Pennsylvania are safe from those who commit violent acts against our neighbors, friends, and children. Since our parole system in Pennsylvania has failed our citizens of the Commonwealth, it is important that the Pennsylvania State House of Representatives, the Pennsylvania State Senate, and Governor Wolf take immediate action to protect our communities. Our legislation would postpone consideration of parole for 24 months beyond the original minimum sentence of each conviction of a violent offense while incarcerated. Additionally, our legislation would postpone consideration of parole for 12 months if an inmate attempts to escape, smuggles contraband, or retaliates against any witness while incarcerated. Pennsylvania has seen a string of violent criminals released into our society, put right here on our streets, only to see them reoffend. We cannot allow these violent offenders back on our streets where they harm innocent people. Our legislation is supported by the Pennsylvania State Correction Officer Association, the Pennsylvania District Attorney Association, our district attorney here in Lawrence County, Joshua Lamacusa, and the family of Marky Mason. And it is also receiving bipartisan support from legislators in Harrisburg. I look forward to any questions that you may have.
Specifically, had these postponement requirements been in place in Burley's case, what would the effect have been, and based on what actions of his while he was in prison?
Well, thanks for the question, and I'll just repeat the question for folks that may not have been able to hear. It was, what would our legislation have done specific in the Burley case? Had it been in effect. So, first and foremost, this is a horrible tragedy that occurred. And it's not the Burley case. To me, it's the Marky Mason case. This is about a child who is viciously murdered. And what I see with that is the following. This is just one of the circumstances that have happened due to the poor actions or inaction of the Department of Corrections and the Parole Board. So in this particular instance, this animal would have been kept behind bars for a significantly longer period of time due to his actions in prison. Now, I'm not sure how much of the reports are public right now, but I can tell you that he had many offenses while in prison. And what I know today is, would our legislation have been in place at that point in time, that Marky Mason would be in school today at 11:15 in the morning.
So, but your legislation would be on the basis of convictions. Any convictions
that is
have
correct.
to be public records. So, do the math. What convictions would he have?
Yeah, so I know that there was at least one conviction. There were several other issues that he had in prison. Our legislation, like I said, today, what would have happened is Marky Mason would have been today at school instead of in a cemetery.
Aaron, how quickly do you think you're having bipartisan support? How quickly do you think this will get back?
Well, I think to me this is a very common sense piece of legislation. Now, common sense doesn't always mean that it passes so quick in Harrisburg, as you folks in the media know. And Josh will tell you as well, we've worked on several other pieces of common sense legislation. What I can tell you is this, and I think that this is very important. I've had some direct conversations with the team that works with the chairman in the House of Representatives. We're going to work very hard to get this done right away and moving through. We've had no objections. The Department of Corrections has not objected to this. We have many people that are on board with it. So I do anticipate this to move forward, get it through the House of Representatives. We'll look forward to working with Senator Vogel over in the Senate. And my guess would be that the governor would sign this. If he doesn't, then we'll work to override a veto. But to me, this seems like very good common sense legislation. And we're going to attack this full force as soon as I go back to work on Tuesday in Harrisburg.
Before the end of the year, you would hope?
That's my goal.
How many parole board members actually voted on Burley's parole, and were there any dissenters?
Yeah, I don't know that particular. I don't know the particular facts of those. I'm not sure if you can address that or not.
I'll address it. Yeah, I do have the documents. All of it is contained within the documents. You're going to have to request those from the Department of Corrections and the Probation and Parole Board. But again, Secretary Wetzel seems like he wants to be as transparent as possible. So that's part of the documents that I would request specifically from them.
Is there anyone from the Department of Corrections that's actually, or the parole board that's actually said we goofed on this one?
No one said that. The internal report, and I can talk about the internal report itself because it was made public. No, there was obviously there is blame on the offenders. I mean, let's be honest and let's be clear here that the people who committed these crimes, they have to be held accountable. They made the choices, they made the decisions to commit these horrific acts. You can't put that blame for their actions specifically on, you know, the parole board. However, the parole board did create a scenario where these men were released upon the citizens of the Commonwealth of Pennsylvania, and it was their decisions based upon the information that was presented to them, based upon their evaluation of that information, that ultimately resulted in their vote that released these men.
So, to put a finer point on it, are you saying, and both of you answer this, are you saying that there needs to be a substitution for the judgment of the parole board members because you feel that their judgment is inadequate or failed?
No, I think that the system that we have constructed in Pennsylvania is a system that is gathering as much information as we possibly can and then presenting it to the members of the parole board. My main concern, and this is certainly the concern of Representative Bernstein, is that the philosophical shift that's happened in Pennsylvania to try and get men and women out of our incarceration system has been done in a haphazard manner. And we are not making a distinction between violent offenders and nonviolent offenders. Now, the Department of Corrections and the Parole Board are going to say that, you know, there is a methodology that they use to evaluate these cases, and there's a violence forecast model. And it was mentioned several times in the report, and it's talked about. Well, obviously, the model is not successfully predicting future violent conduct, because within 2 months, we had 6 people dead, committed by 5 different parolees that had not been on the street that long. In fact, in the Burley case, he'd been on the street 3 months. So what I believe needs to occur is they need to take a look at how are they collecting the information, what is the basis of the information, the methodology that they're utilizing, and then how is that being presented to parole board members. I know that the District Attorney's Office in Lawrence County never wrote a letter about Mr. Burley, about whether he should be incarcerated or continued incarcerated. This is another failing in the system where you have district attorneys who you know, we are elected for 4-year periods of time. And so if a man or woman is serving a sentence of incarceration that is longer than the term of the current district attorney that incarcerated them, there is a disconnect there. So this would have been a man that was convicted 20 years ago, 10 years prior to me taking office, never received any notification as to what, you know, what should be done with this man. That's a problem, one of the many problems that needs to be addressed in the system.
Would this in effect, you'd have a pool of potential releasees that the status of a conviction would automatically remove him from that pool so that he couldn't even come up for consideration?
Yeah, I mean, that's my understanding of the legislation.
Is that accurate?
Yeah, so very simply, if the violent inmate is convicted of a violent offense while in prison, it would push out for each offense that he's convicted of, it would push out that minimum 24 months. So if that's 2 times or 3 times, right, multiply those times 24 months. Now, in addition, should they try to bring in contraband, or should they harass a witness, or any of those types of things that are mentioned in the report that you folks have, then it would be 12 months for each of those instances. I think here's what we're trying to say, and this is of great concern for me. And when the district attorney and I spoke at first, and then we had some initial phone calls with some stakeholders, the answer that we heard from the Department of Corrections was, well, those instances happened a long time ago. Well, what we're saying is, if this person was in jail for 20 to 40 years, the Department of Corrections is nearly openly saying, you can do whatever you want for the first 10 years that you're in prison. There's no penalty for acting out. There's no penalty for committing violent acts, because, you know, those would have been a long time ago by the time you would have been released. That doesn't make sense. And I'll tell you, the other thing is, we have men and women that are putting their lives on the line. And I'm not sure if you've ever visited a prison, but I would encourage you to do so if you haven't. And, you know, there's 1 or 2 of them per 60 inmates, 70 inmates sometimes that are around. And it is putting the inaction by the Department of Corrections on this issue and not holding these violent inmates accountable is putting those Department of Corrections officers in danger. And I don't think that's fair to the people that are just trying to go home every night either.
Any other questions?
Can I ask you something on an unrelated matter?
Unrelated?
Yes.
Maybe.
The juvenile who is alleged to have admitted making the threat against an unspecified hospital in Pittsburgh. Originally, the word was that that person was in Beaver County. The Beaver County DA told me actually it turns out that his residence was across the county line in your county. Can you give us any update on the status?
I can confirm that the residence is within Lawrence County and that the case is presently under investigation.
So no decision's been made as to whether as an adult or as a juvenile take any action?
Not yet.
How soon might that come?
Probably within the next 30 days.
Thank you.
Yes, sir.
Josh, just to clarify what you said early on, you formally filed papers on Burley for the death penalty specification earlier this month.
I did.
Right?
Yes.
When is his arraignment then?
I've not received the confirmation of the arraignment date, but in all likelihood it'd be next month. And then at the arraignment, that'll kick in the formal process of when he'll have to file some legal motions to determine, is he going to plead guilty? Is he going to plead not guilty? Is he going to try and suppress evidence? Then after arraignment, if he, whatever legal filings he makes, we'll have to address those. And then after that, we'll head to trial.
For arraignment in your county, will that involve an actual appearance in a courtroom, or is it more of a paperwork process?
Arraignment is the same everywhere, so the defendant will have the opportunity, if he wants to appear, he can go into the courtroom and the judge would provide him the rights that are afforded to every defendant in a criminal case at arraignment. If he opts not to appear, then the attorney can file a waiver of appearance, and then that's just a paperwork.
But you don't know what...
I don't know yet. That'll be up to the defense.
In Ohio, when there's a death penalty case, there are certain specifications that can bring to that.
Yes.
How does that work in Pennsylvania? Are there specifications that bring in the potential for a death penalty?
There are. Under the Pennsylvania statute, there is a list of what's called aggravating circumstances. A lot of times people think that if the case is premeditated, that means it's an automatic death penalty case. Well, that's not true in Pennsylvania. In Pennsylvania, you have to have very unique circumstances in order to certify the case for death penalty. In this particular case, there were three factors. One, that he had been previously convicted of murder before. Two, that he was committing a felony when someone died. And then three, because it was a child under the age of 12. We don't need three of them. We don't need two of them. You just need one. But there were three factors that actually covered the circumstances in this case.
Just in your opening remarks, you had said some things about seeking records from the parole board and from the state regarding the process. Is that regarding the Burley case specifically? Was that regarding cases involving your county, or were you making a broader request for the entire process?
My request was, my subpoena was specific to the Burley case because those are documents that are going to be relevant whether to the Commonwealth or to the defense when we're pursuing the death penalty. So
that's your focus.
we had to focus on that, yes.
Who would have authority to do something broader? Would it be the Auditor General?
The Auditor General absolutely could do it. But again, if Secretary Wetzel is going to stick by what he said, it sounds like he'll give you the documents. I would request it and see what happens.
In terms of some sort of independent review by an agency, that
Yes.
would be one possibility.
Yes, that would be one possibility. Any other questions? Yes.
Is there any mechanism in place that would require the parole board to send a letter to the DA's office of the county when that person is about to be released if it's a violent offender?
There is. With the district attorneys, we do receive letters when someone is up for parole consideration, and then we have an opportunity to provide input.
Did you get one for?
I did not get one in the Burley case. I did not provide a response because I did not get one. We used to receive them via mail. Now they're emailed sometimes. Every once in a while I'll still get one by mail, but there is a process. I don't know how seriously they consider our reports. I'll give you a specific example. Case of Commonwealth versus Sean McDonough. This was a cold case homicide that happened back in the early 80s where a young woman was killed. Her name was Laura Thompson. We hunted the man down. We convicted him. The parole board sent me notice, a letter of their intent to consider him for parole. I wrote back what I believe to be a very scathing response, saying this man killed a 17-year-old girl and then buried her body in the woods. He was released at his minimum, which is unfathomable.
So in the Burley case, just to, I'm not sure that I got your answer to her question. You were given notice that he was being considered, or you did not receive notice?
The Lawrence County District Attorney's Office never received notice that he was being considered for
But
parole.
you're saying that under the rules you should have?
Yes.
So there was a failure to notify.
That would be the inference. Anything else? Thank you. Thank you guys very much.